Let's bring back in National Trial Attorney Michael Jaafar just to react to where we are in the state's case. All three roommates have testified, and boy, it's difficult just to see what this must be like in their lives. This tragedy to happen to them when they were so young, to have someone that they cared about so much gone.
Yeah, the state's case is a tank. I mean, they are doing exactly what they need to do. They are, right now, obviously, they're winning this case. They're going basically 1, 2, 3, 4, 5, right down the line of everything they need to do. They're doing it well. They're doing it great. I mean, obviously, everybody would wish that this never happened. With it being happened, if we're just talking just about strictly the case and how it's going, the state is absolutely doing a 10 out of 10 job. And I feel bad for the defense. Obviously, I feel bad for the family of this woman. But in terms of the case, I feel bad for the defense because this is the most difficult case to defend as a defense team, right? This is the most, it doesn't get more difficult than this because you have nothing, right? You have absolutely nothing. What do? You're seeing the defense attorneys, they're talking about her clothing and what she was wearing that day. Obviously, it's not really right. If you're a defense attorney, what you would really like is an alibi, right? What you would really like is, hey, they saw somebody else. What you would really like is there's somebody else, a jealous ex-lover or something like that. That's what you would really like. But you don't have anything. You have everything against you. So the case is going perfectly for the state.
That's what we're hearing there inside of the courtroom from the defense. Michael Jaafar, thank you for that analysis. We do want to go back in. We've been behind because we've been pausing it during the commercial break. So the lunch break is now over, and the next witness is on the stand, crime scene specialist Daniela Stewart.
Joining us now to discuss, Michael Jaafar, trial attorney. Michael, I do want to start with you. This is a bench trial, not a jury trial. We are seeing the prosecutor really go through the evidence in this case very quickly. When we see jury trials, sometimes, for instance, when a prosecutor holds up a rock, they've been showing rocks, they will walk by, show it to the jury. It's a very different scene inside the courtroom here because she's just holding it up really quickly, showing the judge, he sees it, and then that's the extent of it. What are you seeing so far from her presentation of the evidence?
So far, it's a 10 out of 10. And yes, bench trials are a lot more efficient than jury trials, significantly more efficient. That's not why they did it here, but they're significantly more efficient. It's faster, it's crisper, it's shorter, less dramatic. But she's doing a 10 out of 10. I mean, this is a home run case for the prosecution. It's not the defense's fault. It's just this is the facts that they were given. This is the case that they were given. This case is a home run for the prosecution. They're so far doing a very serviceable job. I rate their performance so far as a 10 out of 10. It's going to be a mountain for the defense to find some way when they take this case to find reasonable doubt. Even in their cross-examination of the prosecution's witnesses, the cross-examination is also very short, very succinct, and in my opinion, not persuasive in any way, shape, or form. They're talking about her clothing and where was her shirt, where were her pants, did you see her navel? So far, it's going perfectly for the state.
Okay, eventually you're going to see the witness showing the judge a part of the tree. So they showed everyone in the courtroom. We got a chance to see a photograph of the tree with some hairs that they said belonged to Laken Riley. And then eventually the witness on the stand is going to hold up just a part of that tree that they cut down to use as evidence and preserving that crime scene. Michael Jaafar is still with us. Michael, before we were talking about the bench trial versus the jury trial, you were mentioning efficiency. You said in this case that's not why they had a bench trial. Can you expound on that a little bit as to what you believe the reason was for Jose Ibarra choosing a bench trial?
Yeah, it was very clear, not to be too overly political, but the political climate this month in Georgia was the sort of political climate that would have, the defense attorneys believed that it would have been more difficult for him to get an acquittal with a jury of Canton, people living in the Canton area, as opposed to just a bench trial having the judge. It was highly politicized, this exact incident. And so they just figured, you know what, we're not going to get a fair shake with the jury. We have a better shot with a jury, with a trier effect of one, a judge who's going to focus on the law, focus on the evidence. Whereas jurors, we know, tend towards the inflammatory. There was too many inflammatory pieces of evidence in this case. The murder itself was inflammatory. The fact that he was a Venezuelan illegal alien, all of that was too inflammatory. The defense believed that they had a better shot with a judge as opposed to a jury. Not to get political, but that's, I was not in the room, but if I was in the room, I think that's what the conversation and the discussion was.
and then made that decision on Tuesday. They let the prosecution know they wanted to do the bench trial instead of the jury trial.